Welcome, friends. Well, you are all aware knowledge prospers all. And in our journey of sharing knowledge, let's begin. Today, we are going to see an overview of the Industrial Disputes Act 1947. Well, friends, this is just an overview as you understand that any labor law or any labor legislation is a notion in itself. But then, in whatever is the time at our disposal, I'm going to just take an overview because we are going to discuss Industrial Disputes Act in detail in the forthcoming videos. So this is just an overview. What is this Industrial Disputes Act? Well, friends, on the eve of Indian independence, that is in 1947, on 15th of August 1947, India got independence. Pakistan got it on 14th of August and India got it on 15th of August. And India, when it got independence, you are all aware, Pandit Jawaharlal Nehru was the first Prime Minister of independent India. And the Prime Minister is also the ex-officio chairman of the Planning Commission of India. And the planning commissions, we had all heavy industries, which were the foundations of the heavy industries were laid down by the planning commissions. So all these big industries, big dams, Bakra Nangal and Nagarjun Sagar and Bharat Heavy Electric and Steel Authority of India are all industries which came into picture. However, there was one problem which arose, that the legal sky was very murky and there was not a proper legislation to deal with the Indian industry. And that is why on the eve of the Indian independence, right in 1947 itself, the government thought it wise to draft a legislation which is called as the Industrial Disputes Act 1947, or which is also rightly called as the backbone of the Indian industry. And we are going to see an overview of it today. What does this contain? Well, friends, the first thing is we have to understand what is the object of the Industrial Disputes Act. Every law, every legislation is with a specific object. Well, this is the object we try to achieve. The object of the Industrial Disputes Act, very simple, is settlement of industrial disputes. Well, friends, I start walking on a road, I see an industry, there are red flags outside. And I just inquire as to what is this. They said that the workers have filed a case against the management and they are on strike. I go to another industry. There the workers are again on a strike for a different reason. There are all red flags outside. Again, there is a strike. Third industry, again, there is a strike. There is for different reasons. Just think, friends. If all over there are strikes in India, India would cease to be a country. India would be a court. Wherein half the Indians have filed cases against remainder of the half. And this is not in tune with the idea of a welfare state which we have already envisaged. So there should be some machineries, there should be some legislation wherein the object is to settle the dispute. When there is a human and human interaction, there are bound to be disputes, but the disputes cannot linger on. They have to be settled also. And this is the object of the Industrial Disputes Act, which is for only one thing, that is settlement of industrial disputes. So the total endeavor, the total demeanor, the total tenor of the Industrial Disputes Act is settlement of industrial disputes. Well, friends, what does this contain? Well, there are many things, but this is just an overview and time also would be short. And it would not be very possible to grasp each and everything and every section contained in the Indian Industrial Disputes Act 1947 in a small video. But some major definitions are there. What are those major definitions? First and foremost, what is industry itself? What is industry? And friends, what is an industry? The definition is laid down as we are passing very quickly. The definition is laid down in the year 1947, which is a blanket sort of a definition that industry is avocation, vocation, calling, trade, manufacture, business, everything. Then you see, friends, what happened is from 1947, when the definition was in the law books, from 47 till 1978, I would call it phase 1, there were so many cases. Say Safdarjung Hospital versus Mr. Sethi. And likewise, the Supreme Court had an occasion to answer different questions, in the sense whether a hospital is an industry, whether a club is an industry, whether a school is an industry, whether a college is an industry, whether a temple is an industry. And ultimately in 1978, there was a landmark judgment, and that was Bangalore Water Works and Sewerage Board versus Rajappa, wherein a full bench of the Supreme Court again decided as to what could be the tenets of an industry. And taking lessons from the judgment, the government in 1982 amended the definition. And as we know, industry means in every industry there is a cooperation of employer and employees for the production, distribution, and supply of goods and services so as to satisfy human wants and wishes. And whether there is a capital invested in the making or whether there is some profit in the undertaking is immaterial for the consideration. Roughly the definition is this way. Where is it? It's in the Industrial Disputes Act. Then there is another definition as to say what is an industrial dispute. Industrial dispute, there is a dispute, but it's industrial in nature. So it essentially has to be in an industry. Just to give you an example, friends, say today morning, I had a couple of fights with my wife. Can you say there were 2 industrial disputes in my house? The answer is a simple no, because an industrial dispute requires the existence of an industry. An industrial dispute, roughly the definition, I'm saying roughly the definition is a dispute between workmen, employers, workmen, for the employment, non-employment, terms of employment and conditions of labor of any person. Then say an issue rose in those days as to us whether a solitary dispute can be called as an industrial dispute. I am a worker on the one hand and the total management or the company on the other hand. Can it be called as an industrial dispute? And this is also laid at rest now that yes, for dismissal, discharge and all of those things, it is an industrial dispute. Section 2A is introduced into the Industrial Disputes Act. Very quickly, friends, the third definition, many a times we are perplexed. Who is a workman? A workman is a person who does manual, skilled, unskilled, technical, clerical, operational, and supervisory work to whom the Army, Navy and Air Forces Act is not applicable, whose wages are less than 10,000 rupees per mensum as per today's definition, and who is basically or mainly not employed in a managerial cadre. And then there are umpteen number of judgments on this. Then what does the law contain? Industrial Disputes Act also lays down machineries for settlements. I told you. The object of the act is settlement of industrial disputes. So what are the machineries? Various machineries are laid down to settle industrial disputes. Say for example, works committee, where there are more than 100 workmen employed. There is a committee which is called as a works committee, wherein which contains representative of employers and employees in equal numbers. And they decide day-to-day matters. Serious matters are not decided. Say for example, what could be the menu in the canteen? Food is a big trigger in many industries. Half the fights are because of food. And yes, a man works for food. So you have a committee, what could be the menu? So that there are no frictions between management and the workmen every day. How should the cycles be parked? Simple issue. You have a works committee. Next, friends, is the Conciliation Officer. The word reconciliation comes from the word to reconcile, means to bring together and settle the dispute. The duty of the Conciliation Officer is to go from camp to camp, that is, he meets the management, he meets the worker, and then sees whether there is an amicable settlement. He acts as a friend, philosopher, guide. Where is it written down? Industrial Disputes Act. So he'll call the management, he'll call the worker, and then make out reasons as to why a settlement is reached and why it is not reached. But he'll make an every endeavor, remember, to see that there is no dispute. If at all it results in a failure report, he'll send a failure report to the government, and the government will make a reference which will either go in the industrial court or to the labor court. Third is the Board of Conciliation. Board of Conciliation, friends, could be a magnification of the Conciliation Officer. There are some issues for which a wider deliberation is needed. And in the Board of Conciliation, there is a chairman, equal number of representative of employers, again employees. Say for example, when would permanency be granted to Jilla Parishad employees? They are in huge numbers. And they come every year for work for some days. Then there are heavy rains. They work in the countryside. There are mountains and this and that. So these people said, when would we become permanent? For which the government appointed a board which is called as the Board of Conciliation. Likewise, there could be many issues. Then there is Court of Inquiry. Court of Inquiry is a single person. And then he will listen to the parties give up his report. That would be, and what am I talking? Answer is these are all settlement machineries. Then, friends, is a labor court, which some schedules in the Industrial Disputes Act are referred. Same is with the Industrial Tribunal. Some schedules are referred. They will adjudicate upon them, and then ultimately is a national tribunal. Suppose if the industry is in various states, so there will be a national tribunal which will be constituted. Then, friends, we are having, say, Section 9A of the Industrial Disputes Act, which is a very important section. That these are a set of conditions as far as workers are concerned, and you want to change some condition. Can you do it outright? The answer is no. For which you have to give a 21 days notice to the workers, which is called as a notice of change. And this essentially has to be in consonance with Schedule 4 of the Industrial Disputes Act. Schedule 4, if you read, friends, it's all a vast one. Hours of work, wages, this, you just think of a condition of service, it's already mentioned there. Then, friends, we come to strikes and lockouts. So many strikes, so many. I mean, what could be a lockout? Strike is the last weapon in the armory of labor. And there are different types of strikes. We have, say, a general strike is there, en masse casual leave, sit-in strike, stay down strike. Then pen down strikes are there, hunger strikes are there, gheravs are there, go slows are there. Then say quickie strikes are there, lightning strikes are there, sympathetic strikes are there, so many of them. Strike is defined in Section 2Q of the Industrial Disputes Act, that it's a total cessation of work by a body of persons acting in combination or a concerted refusal under a common understanding. Roughly, the definition is this way. And then there are strikes in public utility services. Then there are certain conditions. How many days should the notice be given? Whether you can proceed on a strike. When can you proceed on a strike? What would be an illegal strike? What is a legal strike? Lockout, friend, is an antithesis of a strike. It's the last weapon in the armory of management. And then normally the rules would be the same. Parallel, I would say, not the same exactly. And then, friends, so lockout. Why would an employer declare a lockout? Lockout is not temporary. I'm sorry, lockout is temporary, not a closure. And then there are certain things we see. Say, for example, what is a retrenchment and what is a layoff? Retrenchment is defined in Section 200 of the Industrial Disputes Act. That it is any termination is retrenchment. Then there are some exceptions also. Non-renewal of contract, continued ill health, superannuation. They are outside the pale of retrenchment. And then what are the conditions? I mean, sometimes the employer has to axe down some workmen and he cannot obviate a retrenchment. The situation is too inevitable. So what it does is you have to follow Section 25F, that is retrenchment compensation, which is 15 days of average pay per completed year of service. And then sometimes there is a transfer of an undertaking, wherein yes, you can transfer. Ownerships are shifting hands. But if you don't want the workers, again you have to pay them a compensation which is equal to the same. That is retrenchment compensation, that is 15 days of average pay per completed year of service. And then some people say, enough of this, I don't want to do business, I want to close it. If at all the closure is allowed in the sense, see friends, as far as there are industries are of two types, 5A and 5B. Chapter 5A applies where workmen are less than 100. Chapter 5B applies where workmen are more than 100. Where it is 5B, you have to take permissions from the appropriate government also, for layoff also, for retrenchment also, for closure also. So, government permissions for Chapter 5B. If it is 5A, well, the conditions are mitigated. You do not require government permissions. But in a closure compensation, yes, you have to pay the compensation. Compensation is payable at the same rate, that is 15 days of average pay, friends, per completed year of service. Well, friends, then you are having, say, the niceties, I'm not going to speak that whether it's a condition precedent, payment of retrenchment compensation is a condition precedent. That is, you have to pay it earlier before you retrench. Closure, you can pay it later, but we are not discussing all of that in detail. Section 33 is conditions of service remaining unchanged. The matter is before the Conciliation Officer, Labor Court, Industrial Court. You have to take a court permission, or you have to take the permission of the authority. And then you can terminate. Whether an exact permission is needed or an approval is needed, that will depend upon the niceties of the section which are applicable. Then there are protected workmen. Protected workmen means, yes, nobody on earth can do anything to me. No, that's not the meaning. But protected workmen, we have to inform the management that this is a list of protected workmen. What is the percentage? Say, how many maximum people can be protected workmen? It's all laid down in the Industrial Disputes Act, which we are discussing by way of this overview. Section 33C2 are recovery of dues. Say there is a workman, he's worked for some employer and his pay packet is fixed, but he is not paid him, so he will make an application under Section 33C2 to the Labor Court, and the Labor Court will work out all those dues as an execution proceeding. Labor Court will not decide anything. It will not decide the entitlement of a right. The right should exist, and Labor Court will just execute it. And then, friends, there are so many cases also. Cases, let me tell so many of them, right? From Bangalore Waterworks and Sewerage Board versus Rajappa, I mentioned, say, Sabdarjung Hospitals case, Radha Swami Satsang Sabha, TTD case, that is Tirupati Tirumalai Devasthanam, then Royal Calcutta Golf Club, Mazdoor Union, Sundaram versus Bal versus Goa government, whether school is an industry, then you are having, say, whether club is an industry, Cricket Club of India. So many of the cases, whether he is a workman, she is a workman, strikes. I mean, it's an ocean of cases, which it's impossible for me to just cite in a small video, because we are just concerning, or we are concerned about the overview here. So, but we are going to talk on each and every aspect of the Industrial Disputes Act, friends, in detail. Today is just an overview, isn't it? And we always believe in sharing knowledge. And sharing knowledge, you and me both are students. And in our journey of sharing knowledge, let's enjoy the video till we have another one on another topic. Thank you, friends. Thank you so much.